Okay, it looks like everybody is back and accounted for. Thank you very much. At this point, we will reconvene the Yamhill County Board of Commissioners for February 25th at the point of item I-7, consideration of a Yamhill County Second Amendment Sanctuary Ordinance. Commissioner Bershauer. Oh, Ken?
If I may, before we on the agenda, I just wanted to quickly talk about the public comments that we've received, because we've received a lot of public comments that have come in up until, and just like the agenda says, anything that would become part of the record for this meeting is any written comments received up prior to the meeting. So I just wanted to quickly address that it's taken staff time to prepare the documents, and so I'm not sure if all of the written comments have been shared with the commissioners yet, because based on the volume and having to break that up into, and consolidate and get it ready to share with the commissioners, they're working on that. But I also wanted to highlight that it appears that we've at least gotten another 83 comments that have come in since the meeting has started. But those, because they came in after the meeting had already started, they won't necessarily be added to the record for this meeting. And I just wanted to clarify that, staff is trying to navigate a large volume of comments that have been coming through the email system.
Thank you for that. And I want to thank Carrie Hinton and Carolina Rook. They received, I'm going to say it's probably approaching 1,000 emails. We did have, so thank you for that. It required printing and scan, and they are going to have to be scanned and put into the public record. The commissioners have received them in their email boxes, but and were able to look at a number of them, but again, the sheer volume of them. We did have a constituent who asked that we keep track of the proponents and the opponents and the numbers so that we could be accurate in reporting how that has shaken out. At this point, I would say the last time I stopped counting, it's probably over 800 in favor of the ordinance, and I stopped at 50 who were opposed to it, but that definitely is going to change. But the Ken.
And I just wanted to also just go on record for the meeting that that's not something historically we have done it as staff on tracking those types of statistics. We basically collect all the comments that have been submitted to the record, and we keep it together as a packet, and it's available for anyone, that once we make it available, they can go through and count, because unlike a land use hearing, when we're meeting over in the old days, when we were meeting in person in room 32 for a land use hearing, where we have a comment card where people would either mark in support or in opposition, just based on the sheer volume. And then, sometimes, we're just trying to compile the comments. We're not necessarily going through and reading every comment as staff, because these comments are for you, the commissioners. And so we just want to make sure that we have a complete record, that we're receiving them and have them in the packet. So I just wanted to head off before we get requests of staff to say how many pro or how many in support and how many in opposition. That's not something that we track as staff.
Thank you for that. Carrie Hinton just let us know we have at this point 1,118 just in of the, I guess, in the last batch. And we did have a constituent who asked that we keep track of that. And so I was just sort of anecdotally, informally keeping track so that I could respond to that request. It does look like the overwhelming number of emails that we're getting are in favor of that. But that, again, it's not official. It's just from eyeballing the emails that are coming in. And that's neither here nor there, and it's not official. So Commissioner Bershauer, you brought this ordinance for our discussion. Turn it over to you.
Thank you, Chair. And I just wanted to note too that while we've read some of them, we have not read all of them. A lot of them came in after 10 o'clock after this meeting started. So I do want to make sure that the public that's listening knows that we intend to go back and read them all, even though at this point that hasn't been done. I brought this ordinance forward. This has come before the board a couple times before, I think in 2015 and 2019, I want to say. I think it's imperative that we consider an ordinance like this. Personally, my personal sense of frustration and urgency is Senate Bill 554, which just passed out of committee this morning. A bill like this, and this is just one example, but a bill like this essentially targets lawfully abiding CHL holders. I happen to be one. And it will create a minefield, what I describe as a minefield. You can call it a patchwork, but minefield sounds more appropriate, where cities and localities, municipalities can create, in essence, gun-free zones in their public buildings. So, for example, the city of McMinnville City Council could vote to deem all of their public buildings as gun-free zones. And what that does is it creates a patchwork of places that lawfully abiding CHL holders cannot go. The consequence of going on the premises or even adjacent to, which is in the language of the bill, it's anybody's guess as to what adjacent to means, but I'm assuming it means next to the building on the sidewalk, that the consequence is a Class C felony, which I confirmed with the sheriff is an arrestable offense, as well as up to $125,000 fine. So in essence, you are creating felons out of otherwise lawfully abiding CHL holders. That's a problem. And it's very frustrating that the effort in Salem specifically seems to be against lawfully abiding gun owners, firearm owners, rather than addressing really the root cause of gun violence. And so my purpose in bringing this forward is really to protect the lawfully abiding gun owners and people who visit our county, so that they are not unfairly targeted or cited or arrested or prosecuted for something that otherwise wouldn't be a crime. I fundamentally believe that it's our constitutional right to bear arms, and I do so myself. And I feel that the legislation coming out of Salem and potentially coming out of the federal government is so egregious that we are now at a point where we need to stand up and protect our residents. What the ordinance does not do, and it's modeled after Columbia County's ordinance, which was brought forward by the voters, not the commissioners, but the voters. It's modeled after that one. What it doesn't do is it doesn't allow for the invalidation of any other firearm regulation. So state, federal law does not invalidate those. It also does not allow felons, people who are convicted of a crime, or underage folks or anything like that, to essentially get out of being charged with a crime that involves a firearm. What it does do is it essentially says, and it directs our county officials to not enforce certain regulations around firearms that we deem inappropriate. The discretion falls to the sheriff, but he already has discretion, but it continues to fall with the sheriff as well as the county commissioners now. And the sticking point is really the expenditure of county funds. We're basically saying that the county is not going to spend resources or funds on the enforcement of certain firearm regulations. So an example is, if I get pulled over for speeding and I pull into the parking lot of the Newburgh Library, and the Newburgh Library Board has deemed itself a gun-free zone, not only am I getting a speeding ticket, but now as technically, as a CHL holder, if I'm carrying my firearm, I am guilty of a Class C felony, which is arrestable. So what this would say is it doesn't dictate what a Newburgh Dundee police officer can do or cite for. However, when it reaches the point where I'm either booked into a jail or any sort of county resources are expended in the process, it puts a stop to that. So it doesn't prevent the enforcement of other laws, but what it does is it doesn't unfairly target CHL holders for these very reasons. And I would like to open it up for discussion because I know this is a very important topic for all of us. And then I can address to some of the concerns I have that the sheriff had as well when I met with him.
Thank you, Commissioner. Commissioner Kula, did you want to comment?
Yes, thank you, Chair. I thank you for that presentation. I must say that when I read the draft or the sample that's in the agenda, which is itself not an ordinance, I didn't see the same level of very specific allowances, disallowances that you presented, and so that's good to hear. You may want to make it pretty more clear in the document than the things that are allowed and not allowed, because I think there's at least two spots where they're not connected in time, but one says firearms and the other says, well, all firearms except for things that are fully, or we draw, it sounds like at some point it draws a line between fully automatic and not. So I think that should probably be clarified. My questions on this one arise from the statement is that this proposed ordinance would not forbid other jurisdictions than within it. And that was, or at least that's what I was hearing, is it wouldn't forbid other jurisdictions from say adopting gun-free spaces in accordance with this bill. And forgive me, I haven't actually read that bill. There were several emails that referenced it, and then Christian sent it to me. I did not get to reading it yet because I was hoping that we'd have a little bit of time here to discuss it, look through the comments. But what I wonder about is in your hypothetical where you're at the Newburgh Public Library and you are arrested by a Newburgh Police Department officer for having a gun, a firearm. I'm going to try to use just firearm. For having a firearm in a firearm-free zone. Under this proposed ordinance, you couldn't be booked into the jail because that would violate the ordinance. But could the DA charge you? Could you be tried? Could you come before a judge? And I say that because I ask about that because, you know, the DA is like kind of an employee of the state, but kind of, you know, our district attorney as well. And so that's one of the areas where I'm like, can we forbid the judicial department from doing things? Or maybe this isn't attempting to do that. So that I'm just a little bit confused in that area at the moment.
Thank you, Commissioner Kula and Chair. My understanding is that the trigger, for lack of a better term, the trigger of it is that it's any county resources, assets, any sort of funds, anything that's coming and originating from the county cannot be utilized to enforce some of these. Now, it doesn't mean that we can't enforce any gun laws or restrictions. It means that we are assuming the kind of legislative authority to do so. We are working with our sheriff to determine what we are going to enforce and what we are not going to enforce. It doesn't mean that it's a free-for-all in Yamhill County, but it is a very clear communication to other jurisdictions. And you're right, it would not give us any authority to dictate what cities do. They would, and especially under Senate Bill 554, if it passes, they would have the authority to determine which public buildings are gun-free zones. So we can't stand in the way of that. We can certainly not declare any county buildings, public buildings, gun-free zones. It also does not prevent us from deterring the actions of city law enforcement. But what it does say is that when that comes into contact with the county, you hit a wall. Because of this ordinance, you are not allowed to spend county funds and resources on enforcing something like that. Now, the sheriff asked, okay, what does that mean for a crime that's committed when the gun itself is the aggravating factor? And would that prevent me from charging somebody with a crime and the gun is now the aggravating factor? And the answer is no, it wouldn't prevent him from doing that, because he does continue to keep some of that discretion. It's just that now the discretion is also falling on the governing body of the county, which happens to be the county commissioners.
I want to respond to that question about the DA. The DA would come under the auspices of the county, and also to the reference to fully auto. Those are illegal. And so those are patently illegal, and that's not to be confused with semi-automatic, which is what most firearms are, handguns. But fully auto is patently, it's a federal crime. So it goes without saying that that's not something that we could possibly legislate.
Okay, then, thank you, Chair. I guess I wrote down something that Commissioner Bershauer said, which is that we will be the ones to determine which firearms regulations to enforce, but wouldn't that allow us to decide whether to enforce a ban or not ban on a fully automatic weapon? I'm just a little confused there.
No, that's not what we're saying. And just for instance, as if that's not what the ordinance is suggesting. The ordinance is simply suggesting that when the state legislature, when federal legislature makes rules regarding these types of restrictions, this is something that is already very clear, is that the only people who can own a fully automatic weapon is someone with a federal firearms license. And if you want to ask about whether or not we should determine what law, Christian, did you want to weigh in? Did I see you raising your hand earlier? No.
At some point, but please go ahead and finish your thought.
Okay. So if we want to determine what laws we decide that we're not going to enforce, this ordinance takes into account that there are more and more bills coming out of the state legislature, which are more and more restrictive, for instance, to people who have lawfully, they've gone through the process, they've gone background check, fingerprinted, paid the fine, pay the fee, and now they're being restricted in terms of where they can go. And I believe there are between 600 and 900 jurisdictions that could make the determination. For instance, where I live, there is a CPRD property not too far away. I live in an extremely rural area, which means I could not walk anywhere near another rural area carrying a concealed handgun, which is pretty much kind of hard to amount. So basically, the county could not necessarily enforce. But if you want to talk about that, the state of Oregon is a sanctuary state, which means that we have chosen as a state, or the state has chosen, not to enforce federal immigration law. For instance, in your particular business of growing and selling marijuana, that's not something that the federal government thinks too kindly of, because it's considered a federal crime. So we've made that determination in the state not to enforce certain laws, and people seem to be fine with that. What we're saying is that as a county, we are not going to allow for the further restrictions on Second Amendment rights. Commissioner.
Yes, so as a clarifying, thank you. Commissioner Bershauer said that we will be determining, if this passes, which laws which regulations to enforce and which regulations to forbid enforcement of within our jurisdiction. And so is it just you determine by majority of the board then? Because if a majority of the board says that we're not going to enforce things that are federal regulations, I'm not trying to use the fully automatic weapon as in any way inflammatory. It was just that it was referred, there were lots of references to non-automatic weapons. And so wouldn't it be the discretion of the Board of Commissioners then to determine, since that's what Commissioner Bershauer said, or is it all going forward? That's what I'm confused about.
We can't enforce anything. That's not up to the commissioners.
Exactly, but Commissioner Bershauer said determining which things the county, and I'm merely restating what Commissioner Bershauer said. And I would say Commissioner Bershauer, but I'm not the chair.
Chair,
Commissioner
can I respond?
Go ahead, Commissioner Bershauer.
Thank you, Chair. Commissioner Cooley, I did say that because technically what this ordinance would do is put the discretion back to the local authority. So it would be put back to the sheriff as well as the Board of County Commissioners. The sheriff already has discretion. The sheriff can pull you over tomorrow and, if you, whatever, let's, name 5 crimes, right? You're guilty of all 5 crimes and you did them, but he has the discretion to say, I'm going to let you go, or I'm going to write you a citation and charge you with this. So he already has discretion. What this is saying is that we are going to, in essence, provide sanctuary from the ones that are targeting lawfully abiding citizens, and share the discretion between the legislative authority in the district as well as the sheriff. So technically, you could probably write legislative policy on the county level that describes exactly what the sheriff would like to see enforced and what he doesn't. But the overarching ordinance is to simply say that we are not nullifying or voiding any federal state laws. We are simply pulling back our authority to a local level.
I think I just want to make a clarification. I think there might have been some miscommunication that we would not be able to make that determination. What we're saying here is that basically we don't have that discretion because we have already preemptively said that we are prohibiting these types of restrictions. That's the whole point. So
Chair,
I think we're just, go ahead.
That's what the ordinance says. It does say that, but it doesn't preclude us from then going forward and legislating certain things with the input of the sheriff. But the ordinance itself says that, what you said.
Well, I think there might be a sort of a misunderstanding, and we're just sort of parsing words here, is that we make this by virtue of this ordinance, make it so that, for instance, future boards can't come in and say, like the city of McMinnville did not too long ago. City of McMinnville City Council voted to, which they have under the provisions of state preemption, to prohibit loaded open carry within the city of McMinnville. That's something within their purview. That's something they did, that they had the authority to do. What we're saying is that we are making the determination that should future boards come in and say, we're going to pass ordinances and we're going to do all kinds of things to restrict Second Amendment rights, we're saying that is not something that we would. Go ahead, Commissioner.
I'm sorry, I just wanted to, did you finish? Do you want to finish?
No,
Oh,
go ahead.
Okay. So this ordinance would prohibit future boards of commissioners from doing things? Is that what I heard? And Christian and I have actually talked about this in the past with other things. Is that something that we can do, Christian?
Well, any commissioner, any board can come in and undo anything. We're talking about that this is what this board chooses to do. Christian?
Oh, that's right. I mean, if this board chooses to adopt this ordinance or something similar to it, a future board could amend it or repeal it.
Okay, so then to clarify, Chair Sterrett just said that this is attempting to limit what future boards can do. So how do I reconcile that with what Christian just said?
So what we're saying is we're making an ordinance, and we know that any legislative body. So, for instance, the legislature could come in and we're watching that in Washington D.C. right now. So there could be some unilateral, because there's a change in the political makeup of a board or legislature. That goes without saying. I mean, that's why we have representative government. So what we're saying is that this particular board is making this determination. Should the makeup of the board change, they could come in and say, and make any kind of ordinance. So for instance, if you look at the number of counties that have resolutions supporting the Second Amendment or ordinances, there are quite a number of them, and they've had Second Amendment ordinances since 2013. There's a large number of them. So it's not like this is, we're making this up. I mean, this is something that's been done for a number of years.
And I apologize, Chair.
Oh,
I must have just misheard you.
go ahead, Commissioner Bershauer.
Thank you, Chair. So Christian, to verify, if we approve the ordinance can be amended at any point in the future, and with either more specific language or less restrictive language, and a future commission could vote to just repeal the whole thing.
Yes.
And that is true whether or not the ordinance comes from a vote of the public or from a board of commissioners.
If it's been approved by the voters, then a future board would not simply be able to repeal that ordinance. It would have to go through a different process.
Okay, my understanding was that if it comes forward as a public vote, that the commission then has to almost like vote to accept it in some sort of order or ordinance.
Yeah, there is that process, and I believe that may be part of what Columbia County is now doing. Columbia County passed both its preservation ordinance and its sanctuary ordinance through votes of the citizens. My understanding is they're now going through a process to ratify or validate those ordinances. The problem that has come up when in other counties when that has happened is, and this sort of gets to some of the framework I want to make sure we're all within when we're having this conversation. Questions have been raised as to whether or not commissioners can ratify those ordinances if the ordinance says or does something that is contrary to current state law around preemption of the regulation of firearms. So that's covered under ORS 166.170, and that you all are aware of that statute. It expressly reserves the right to regulate firearms and firearms accessories and elements relating to firearms in the legislature, state legislature, except to the extent that they have specifically granted exceptions to that preemption to cities and counties and others. There are several ways in which that preemption has been taken away, and states and counties can act in certain limited capacities. But for that, the regulation of firearms is exclusively reserved to the state legislature. So if one of these citizen passed ordinances contains language that would be contrary to that preemptive statute, question is, can the board legally ratify that ordinance? That's one question. And we have a similar concern with the way this sanctuary ordinance is currently drafted. It would appear to me that this would also be contrary to current state preemption. We are going beyond simply saying we're going to select and work with the sheriff to decide which existing state or federal gun laws we're going to enforce. Under section 3 and 4 of this ordinance, it prohibits employees from enforcing those laws and goes so far as to say that those are null and void and of no effect in Yamhill County, which doesn't doesn't sound to me like we're retaining any discretion or giving the sheriff any discretion to decide whether or not they can still enforce state law. Now, this discussion has had a lot to do with concerns over pending legislation, and I appreciate the attempts to clarify that what we're most concerned about, or what I'm hearing the commissioners are most concerned about, is potential legislation that's moving through Salem or in Washington, and that we are not necessarily intending that this ordinance would invalidate or nullify any existing state or federal regulations around firearms. If that's accurate, then I think a later version of this ordinance should make that expressly clear, because I think that would resolve a number of the questions that have come up when I've been speaking with the sheriff. And that would get this ordinance closer to, I believe, complying with the current state of preemption under state law. For example, Senate Bill 554 would be another express action by the legislature where they have granted the authority to cities, counties, districts to regulate firearms in the manner described in the statute. So if, for example, we had an ordinance that was specifically targeted not at existing rules and regulations, but prospectively towards, legislation like 554, because 554 would only operate in a world where cities, counties, and districts now have the authority to act in this way. We wouldn't, if we were to pass an ordinance that says we are not going to enforce ordinances adopted by other cities or ports or districts under 554, we have a different set of issues that we would have to reconcile, but we wouldn't any longer be needing to worry about whether or not we're violating state law. The question would be whose ordinance would take priority in that instance, right? How would we reconcile what the city of McMinnville might do with what the county has done, or what a district within the county has done with the county ordinance? And the sheriff and I talked a little bit about this yesterday. I think Commissioner Bershauer, you mentioned what might happen if we have a city ordinance and it is a Class C felony, which could be a felony for which you're arrested and potentially housed in the jail. When I spoke with I was speaking with the city of McMinnville attorney for a different reason, but when we were talking, I asked her some questions about how they go about enforcing city ordinances now. Not all city ordinances are cited into circuit court. Many are cited into municipal court. However, some are cited into circuit court because municipal court is not a court of record. So given that this, as 554 is currently drafted, a violation of an ordinance, and I'm not quite sure how they get to a violation of a policy being a Class C felony, but that may be something to let the legislators and legislative council try and reconcile. At any rate, assuming it's an ordinance, there are certain, and she was going to get back to me on exactly which of the current city ordinances that are ordinances that address criminal matters are cited into circuit court, and whether or not, if the city were to do something under 554, if that would be the kind of ordinance that would be cited into circuit court or not. And then we do need to, or would need to, at that point, reconcile what would happen if it's a violation of a city ordinance and they're brought over to the jail and booked into the jail. Whose ordinance at that point would take precedent? And the sheriff did also mention that in the event that there was a judgment, they would need to comply with whatever the terms of the judgment were, regardless of whether or not we had a county ordinance that might say, no, we're not going to involve ourselves in those matters. So there's your analogy of a minefield or a patchwork is either of those are accurate, because this creates a lot of questions and issues that not only we, but every other county and city and district and port and what have you, everyone would need to try and reconcile. But so there's that impact in the event 554 becomes law, and that's what our sanctuary ordinance is targeted towards. But I do want to just remind everyone that the way this is currently drafted, I think it has some significant challenges in the sense that I believe it goes beyond simply exercising discretion to potentially violate the current state of preemption in Oregon by attempting at the county level to nullify existing state law. Creates a clear, to me, it's a clear violation of those preemption statutes. So if we are in agreement that this is meant to be prospective and going forward, then I think we can take steps to modify and clarify the language in the ordinance to do that.
I wanted to point out that, you know, we don't have the authority to make our own rules, laws. What we do have the authority, discretion, if you will, is to determine how we're going to spend money and how we're going to expend resources. And that's really what this is all about. And then to go back to, I think, Christian, you said something about Columbia County. Now, the Columbia County Commissioners, from what I understand, have not initiated any court validation actions. This is coming from staff. Is this correct?
No, I think it's something that would only happen with the approval of the board.
Okay, but who initiated this court validation discussion?
I don't know.
So it wasn't the commissioners then?
I don't know.
Okay, because my understanding is it hasn't been, the genesis of it was not with the commissioners, that it was perhaps generated from staff, which I think is important for us to note. But going back to what this really is all about is that Yamhill County has discretion on how we spend money. And every year budget time, we determine how much the sheriff is going to have and how much public works, well, that's not a good example because that's state money. But basically how much each department is going to get based on what their needs are. What we're saying is that we as a board and as a county are saying that we are not going to expend resources to enforce these laws. And I think that's important to
But it does, Commissioner, under Section 4, it does declare that these, and this is where it would apply to all existing laws as well. It does say that these laws are to be treated as if they are null and void and of no effect. So that is something beyond simply deciding, in my view, how to spend money. We don't need an ordinance to decide how the board is going to spend money to enforce certain laws or to take action in certain areas. This is, if I'm understanding it correctly, and if I'm reading it correctly, this is doing something above and beyond sort of helping make clear to citizens or staff how the county is going to spend money. It is saying that they shall not engage in these activities in the course and scope of their employment, and that these extraterritorial acts are null and void. And that, to me, I don't know how else you could say it. That to me appears that we are trying to act and enforce and regulate firearms in the county in a way that might be in conflict with state law. And that's part of why I think it's very good that we're having this conversation.
Null and void for spending money. Commissioner Berschauer.
Yeah, and if that's true, then we should clarify it to say that.
Thank you.
Yeah, thank you.
Thank you.
Chair, I think Commissioner Kula had his hand up first.
Commissioner Kula.
It was a race. Okay, thank you, Commissioner Berschauer. Yes, right now it doesn't. Right now the language is very broad. It's not about the spending of money. It actually says enforce, and then it goes on to say these are all null and void. The one thing I wanted to bring our attention to is a slightly different part of it, which is that Section 5 says that any entity, person, official, agent, or employee of Yamhill County who knowingly violates this ordinance while acting under the color of any state or federal law shall be liable to the injured party. And that's one where, forgive me for saying it, it makes me uncomfortable that we would be putting something out into the public that says, hey, staff, you can get sued if you don't know exactly everything about this, especially because right now it is very broad, the previous section.
Thank you for that. I think that what we do on a regular basis, and I think that if you ask county council and our administrator just how many times the county's been sued, it's certainly not something that's unusual. So to say that we expect employees to know the scope of ordinances that are in their wheelhouse jurisdiction, if you will, I don't think is asking anything that we don't ask now. Christian.
So I actually think that what this does might be slightly different than that, because this is saying that no employee could, within the course and scope of their employment, enforce these state laws. So that if say a deputy attempted to enforce an existing state law, this ordinance would say that by doing that, you're acting by definition outside the course and scope of your employment. So I'm wondering if maybe the liability that Commissioner Kuhl is referring to is individual liability. When employees currently act within the course and scope of their employment, they're protected in taking those actions by the Oregon Tort Claims Act and our insurance through CIS to cover us for those kinds of claims. One concern is that the way this is worded now, those folks could be exposed to individual liability, which would not be subject to the Tort Claims Act and would not be subject to CIS coverage. And those folks would then be responsible for defending themselves for acting in what they may very well believe is their obligation under state law to enforce existing state law. And again, I want to point out that what 554 would do would possibly put us in a situation where we aren't talking about a violation of state law. It would be whether or not the county chooses to, and how the county and how it chooses to deal with ordinances adopted at the local level, because they've been given the express authority to do that by the legislature. So in a 554 situation, we would be dealing with a different set of questions than we are if we're talking about the enforcement of existing state law.
Thank you for that. I think those are, I'm making notes of things that I would like to look into and address. Those are good and valid points. Thank you for that, Christian. Commissioner Berschauer.
Thank you, Chair. I wanted to state that we're really not putting law enforcement in any different of a position than they already are in when it comes to enforcing federal immigration laws, when it comes to enforcing the state's view on marijuana and now methamphetamines. It's against federal law to enforce those things. So how is it that we can pick and choose which issues are off the table? And at the same time, I just lost my train of thought.
If I could answer those first two. Those two, the two you just cited were state law actions, not local. I think if we were, for example, to try to adopt a local ordinance here that said marijuana is illegal within Yamhill County, we would run into the same preemption issues that we run into with the regulation of firearms, because that is an area where the state legislature has acted, and we would be in direct conflict with that law.
Right, but if somebody pulls me over for speeding and I also have a bunch of marijuana in the back seat, technically I'm guilty of a federal crime, am I not?
Under federal law, possession of marijuana is still a controlled substance, and yes, but again, I'm not sure that analogy. I'm not sure I'm following how that analogy would apply to the earlier statement that you made.
Well, but another example is someone is pulled over and they are here illegally, and they were speeding. They're essentially, law enforcement has been told that you are to stand down in enforcing federal immigration laws. So while it is technically a federal crime to be here illegally, that is not what law enforcement is doing. So And the other thought I had was that none of these Second Amendment sanctuary ordinances or resolutions across the state of Oregon have been challenged successfully, legally. So I don't know,
Yeah.
we're kind of running in circles when we're talking about what could potentially happen to Yamhill
Well,
County.
and I'm sorry, Commissioner, go ahead.
That was all. Thank you.
Yeah, I don't know that they've been successfully challenged. Frankly, I don't know that they've been unsuccessfully challenged. I don't believe they've been challenged because I am not aware of any of the counties where these ordinances have actually been enforced or been followed in such a way that they could give rise to a challenge. So you're right, they haven't been successfully challenged, but I'm not sure they have been challenged at all. I'm not aware of that completely, but I at this moment am not aware of a example of where they have been challenged and been upheld, or challenged and rejected.
I think it's important to say that we know as of now that these have not been challenged. So they have not been challenged. Some of them have been actually in effect since 2013, and there has not been a challenge. The other point I want to make is that when we make a decision, whether it's the federal laws versus state, so the state says we're pushing back on immigration or marijuana laws, what's the difference between that pushing back and the county pushing back to a state law?
So again, I haven't looked at the sanctuary laws. I haven't looked at the marijuana laws closely, but off the top of my head, if the federal government wanted to make an issue of this and wanted to challenge Oregon, for example, on the legalization of marijuana, I think they likely could. They've chosen not to do that. If they wanted to challenge the state on whether or not the state sanctuary law violated federal law, I don't have any reason to believe that they couldn't do that. Why they have chosen not to do that, I don't know. But I'm not sure how that kind of a conflict would resolve itself. We do have the supremacy clause. The supremacy clause under the federal constitution says federal law, where there's a conflict, will prevail over state law. We have similar preemption statutes when it comes at least to the regulation of firearms in Oregon, that where there is a conflict between a local regulation and a state law will prevail.
And we just see that on a more serious level in terms of who's the bigger dog in the fight. We've got the federal government and we've got the state of Oregon, and the state of Oregon pushing back on two significant federal laws, and
Yeah.
and we still have managed to to supersede that. The other thing I wanted to bring up is there is a law. The state of Oregon has a law that says that people who have their property tax foreclosed on, that the state requires that counties keep the equity and distribute the proceeds to the various taxing districts. And I had asked why we couldn't, as a county, give that money back to the former owners of the property. And then you responded that after much research, that we are required by the state to collect that equity and to distribute to the taxing districts. Now there is a court case, and we're a party to that. Mm-hmm. And there is someone who has made I don't know is the term class action, but it's a lawsuit that names all 36 counties, and we have been doing that. We've been taking money from people, and that is, I think there are only 5 states that do that, instead of just taking the taxes owed. Mm-hmm. So I use that as an example to say that here we are, and we're being challenged on that. So
yeah, and that's exactly right. And depending on the outcome of that case, the current statutory scheme in Oregon around property tax foreclosure will either be upheld or struck down. And the courts are the appropriate place for those issues to be decided. We might face a similar challenge if we were to pass this ordinance, and then that challenge would appropriately be resolved by the court. If the current statutory scheme around property tax foreclosure is upheld, well, then we would be obliged to continue to follow state law, just as we are obliged to follow state law when it comes to the regulation of firearms.
I think we have 16, I don't know, just ballpark, we have 16 roughly counties that have such an ordinance enacted. A couple of counties, Lane and Tillamook, are actually circulating a Second Amendment sanctuary ordinance, and we've not seen a challenge to one. So to say that we could face a challenge is also to, I think that this should be taken into consideration. Commissioner Kula.
Thank you, Chair. Back to Christian's comment to the first observation that it hasn't been challenged. Christian, you noted that as far as you understood, what was it, that no county has attempted to enforce this in ways.
Yeah.
Oh, okay. That was
I'm not
that
aware.
just like, yeah.
I'm not aware of a situation where, for example, assuming they've adopted language that is worded like ours is, that they have run into a situation where if the sheriff continues to believe that it's their sworn duty to enforce state law, if they continue to go out and enforce existing state law, that the county has somehow chosen to, under the ordinance, cite those officers for violating the county ordinance. I don't know that that's happened. But that, again, and I spoke with the sheriff yesterday late afternoon, and he did confirm that that is still one of his primary concerns with the way that the ordinance is currently drafted, is that it could potentially put them in the situation of one deputy going out and enforcing state law, and then another deputy or some other enforcement arm of the county going out and citing that same deputy for violating the county ordinance. So as it's currently drafted, that concern in my mind remains.
I don't think this restricts anything. Anyway, go ahead, Commissioner Bershow.
Thank you, Chair. I did have a conversation with the sheriff as well, and there are parts of the ordinance that he requested clarification on. So my purpose in opening up this discussion today is really for just that, the purpose of discussion, and going through and discussing whether or not there's certain parts of this that need to be revisited. So that's certainly something that I'm open to. I did ask about discretion, and he not only has discretion himself, but his deputies also have discretion. Mm-hmm. So the example that he gave was like Senate Bill 941, when that passed, they have exercised discretion around that before. Mm-hmm. So technically, are you violating state law? Probably, but is anybody, suing over it? No. And there are parts, and he brought up the fact that that there are explicit consequences, if you will, to violating the ordinance, which, frankly, I don't think the ordinance would be complete if you're saying that you're prohibiting an action and then there's no consequence for violating the action. It's just part of the ordinance.
Yeah.
It is also my understanding that the commissioners or the governing body would maintain discretion over if a county employee was found in violation of the ordinance, whether or not it would be pursued. It's my understanding that we have discretion over whether or not that would even be pursued, and we would hold someone accountable. So I just wanted to make those points clear.
I mean, I guess what I'm still questioning and asking myself is, under Section 4 penalties, these extraterritorial acts shall not be enforced by Yamhill County agents, employees, or officers. So that to me is a prohibition on the officer's ability to exercise their discretion. The ordinance says that these extraterritorial acts shall not be enforced. So that's one area where I'm still struggling with discretion, because I absolutely agree they have discretion, and I would go so far as to say that they're likely not I don't believe they would be violating the law in the exercise of that discretion to decide which crime or which offense to charge or to cite someone with in the ordinary course of their work.
And then, Chair, if I might, a couple of things. Probably since the DA, the district attorney, Brad Berry, is also, his work is also affected by this. It probably would be good to hear from him as well, or at least I would like to hear from him.
Yeah.
The other thing is that Commissioner Bershauer said that the county commissioners would retain discretion about whether to declare somebody in violation of this who's a county employee. But right now, Section 5 is actually with regard, the only thing I see about, well, maybe, so this is a separate thing, is that people in the community who feel like their rights under this ordinance are violated by a county agent, that there's no discretion there. They just get to, they get to sue personally.
I think that we've seen in the past, we have had discipline actions. The sheriff has disciplined staff and deputies, and they have come before the board as part of a resolution to a grievance. In other words, there's a process. And so we upheld, in this one particular case, we upheld the sheriff's discipline of a deputy that was then reversed during a future process through a union action. But I just wanted to remind, I think you were there, Commissioner Kula, for that when we had, were you there for that? No, maybe that was before you. Yeah,
I
so
know what you're talking about, though.
it was a case where we had to make a decision on upholding the sheriff's disciplinary action. So, well, maybe what we can do is, since this is just an initial discussion, I've written down a couple of issues I would like to look into and to address, and perhaps we can ask for sure to have the sheriff join us next week. I know he was unable to join us this time, to have the sheriff here because we've been talking about him behind his back, huh? And have him there, have the district attorney and anybody else that we think, well, I think let's just leave it there. Christian?
Commissioner Bershauer had her hand up first.
Commissioner?
Thank you, Chair. My impression from this process and observing other counties is that it's almost like a two-step process where the sanctuary ordinance sort of resets the playing field. And then by virtue of the ordinance, you then have a situation where, yes, all extraterritorial acts in terms of gun restrictions or legislation in general are not to be enforced, but it doesn't preclude us from establishing our own rules, for lack of a better term. It may be that those other counties haven't taken that next step. I don't know. But clearly, in the case of like Columbia County, the sheriff is still doing his job. His deputies are still doing their job. Are they performing background checks on CHL applicants? I'm sure they are. I don't know. We can confirm with him, but I'm sure they are. So there is a sort of next step after we maybe reset the playing field isn't the best term, but when we draw a line around the county and say, okay, you know, we are not going to enforce extraterritorial acts. However, we are going to work with our sheriff to determine what it looks like, what enforcement actually looks like. I don't know if any county has done that next step. That would be worth looking into.
Thank you. Christian?
And again, I think it's very important to keep in mind too, when we're having that discussion or thinking about how we might implement an ordinance like this, are we only talking about future new gun laws? Or are we also talking about not enforcing existing state and federal gun laws? And I thought I heard, I'm not sure which, several of you I think have said things along the lines that this is essentially or primarily wanting to focus on prospective new legislation. And I think we could deal with much of the the concern that remains around the legality and enforceability of this ordinance by making it very clear that this is not intending to invalidate or to say that existing laws cannot be enforced, but it would only apply to new laws. Now, I'm not saying that by doing that we have avoided all future potential concerns around preemption that still exist. But for example, for laws like 554, where the legislature is making an exception to the preemption and granting some additional authority to local entities, our ordinance might very well be effective and more enforceable in those situations. I still think we would have concerns or we would have questions that would need to be asked about a future state law. For example, if the state law says we are now going to regulate firearms in a manner that we haven't regulated them before, they wouldn't be giving local jurisdictions authority to regulate, but they would say we've now decided we're going to step into this new regulatory area as it relates to firearms and firearms accessories. We would still, and our ordinance would still have the potential conflict with that new state law, but it might give us some room to operate in other areas like 554, where it's not the state implementing a new law, it's the state giving local jurisdictions some authority to act.
Thank you for that. All right, so are we clear that at this point what we want to do is do what we do really well here, and that's just kick that can down the road for yet another week?
I would say I would agree that I think it would be helpful to have the district attorney, because the district attorney is one of those unique offices where he is an agent of the state in his prosecutorial capacity, as are his DDAs when they're prosecuting cases. But those DDAs are county employees, and he also has administrative staff within his office that are county employees. The other office that is similar, I don't know if it would make sense to include them at this point, would be Ken. I'm kind of looking at you for DCJ. They're another law enforcement agency that has both officers and administrative staff, where there could be some potential for conflict going forward. But I'm just putting that out there.
Thank you. So, all right, let's do that then. If that's agreeable, we can plan on meeting back here next week and addressing some of these, answering some of these questions, and maybe getting a little more clarity. I really look forward to the sheriff being here. I think it's a great idea to have our district attorney here, and then maybe give us a chance to talk to some of these other counties and see what their experience has been. I'd like to know a little bit of how that all came to be. So Commissioner Bershauer, I know that this is something that you have proposed. So any final thoughts on what you'd like us to do in terms of next week, getting ready for that?
Thank you, Chair. No, I'm fine with that. I think if we want to continue the discussion next week, the sheriff did indicate that he would make himself available. So, and then also DA Berry, if we want to bring him in too. I think that's great. And I would also appreciate a little bit more time to research Columbia County and some of the other ones as well, to see how they've navigated some of these issues. So.
And I will hopefully have a chance to chat with their county council between now and next week as well, to see if I can get an update from her on where they are in that process.
That would be great. I want to thank, I know that county council and our administrator has spent some significant time just discussing this, and appreciate that. And also, commissioners, I appreciate your discussion on this, and also everybody who submitted public comment took the time to let us know what their concerns were. I made note of some of those, and I think a lot of them were brought up today. So thank you all for that. And I don't.
With a kicking the can down the road, I actually get to read all the comments now.
Yes, and there are a lot of them. So anyway, and also staff. So Carrie and Carolina, this has been quite a burden to deal with the public comments, but we appreciate the fact that they have come in. Did you want to say something, Commissioner Kula?
Well, Christian had started speaking.
Nothing? Okay. Alrighty. So I don't see that. Let's see. We've got that. Public hearings. We have none. And I'm going to assume that we can hold our comments. I've got Northwest Seniors in about 7 minutes. So I need to be on that call. And Christian wanted to give us an update on soccer, but unfortunately I see I see that I'm looking at the clock here and our time is short. So thank you, Christian. Maybe we can address that next week. You keep that handy.
And
Available at the discretion of the board, always.
Chair, what I might do, since we've put off announcements a couple weeks, is I might just send a quick update from my areas of liaison responsibilities to Ken and Carrie and Carolina so they can forward it on to you.
And also, I've got a bunch too. Maybe we can, I'd really like to have if you can you wait till next week so we can do those? Because I think what's missing a lot of times is we don't get to tell other commissioners what we're doing and what has been done. And there's a lot. And sometimes you can't put it in an email. So if you're okay waiting, I'd like to hear from everybody on what's been going on. There's been a lot. So thank you for that. And so at this time, I'll go ahead and adjourn today's meeting. Thank you all for the discussion, and we'll see you back here next Thursday. Thank you.
Thank you.
Thank you, Chair.